Hello? Somebody else must be live, I'm assuming. If anybody's out there, I dropped the link. Feel free to come up on panel with me. And I think something's going on that nobody told me about. Where's everybody? Yeah, right night. This is Tuesday at 9, right? I do lose track of days, but I'm pretty sure it's Tuesday. All right, I'll just wait till a couple of people get here. I see Marcella Chichester, the lady who rammed her car into the Swan Boat Club, killed 2 children and injured a bunch of other people. She had her preliminary conference today, and she waived the 21-day limit on the preliminary exam. And the defense said they needed more time because of the extraordinary amount of discovery. So apparently the prosecution's got their ducks in a row there, and a lot of discovery. I think a lot of people are gonna come out and talk about how she was I don't know, I don't want to be sued for defamation, but I think she was a well-known figure in drinking circles in that town, from what I've heard, and what a couple of people testified to in the original proceedings. So the judge took a recess and then came back, and unbelievably, no one signed off, closed it. But the next, I think, hearing, the pretrial hearing, is September 24th, I believe. If I'm not mixing that up with Jared Lysak, I can't remember. Okay, who's in the bushes? I can't do this without people in chat. So then I also have the Jared Lysak. I posted an update to that. Jared, what was his trial? The 24th? Yeah, maybe that's the one that's the 24th to the 27th. The prosecution asked for a larger jury pool. Hi, Sonia. Hi, Melissa Brown. I'm just catching everybody up on cases while I wait for people. I can't do a discussion without discussees. So hey, squirrely girl. Welcome. I don't think anybody's going to show up. I'm like, what the heck's going on tonight? It's like, was this a holiday and no one told me? I don't know. I rarely know what day it is, but I did double check. So Jared Lysak from Adventures with Purpose, the prosecutor asked for 70 people in the jury pool to pick from instead of the regular 40 because of the notoriety of the case. She thought it would take more, but why do people still fawn over him? He's just pretending like nothing's going on. I don't know, squirrely girl, can you message her? I texted Chris to get over here. Jared's just pretending like everything's normal, and then he's trying to sue Josh Cantu, who was his videographer, and he did 11 copyright strikes on his YouTube channel. He's just trying to bury him. Why sue him? I don't know. I'm just baffled. I'm really baffled. Some people have no shame. That's it. And we know he's a narcissist from just his actions previously. So I don't know. But I still see people like in Sebastian's case and in Riley Strain case recommending, oh, let's get Adventures with Purpose over there. The guy's accused of raping his sister and his cousin. So why would we want him over there? Then they got rid of the other diver, didn't they? The other search team. I can't remember what the name of that is because he was a sex offender. Who's fawning lover? What? Hey, Misha. Christopher. I don't know where the heck he is. I texted him. I don't know. I hope he's not stepping out on you, squirrely girl. What was it? Oh, who's fawning over who? Misha. People fawning over Jared Lysick from Adventures with Purpose. I don't know why they think he's awesome. Apparently, they don't know about his record. I mean, if you follow anything on YouTube, it seems like you'd know that. Oh no! I don't know. Just a minute. I could try calling him. He'd be pissed if I Oh, there you go. Chris, I'm gonna block you for that. Oh, Misha. All right, and here we go with the dating game. I don't know where Eve is. Eve okay, squirrely girl? God, I haven't talked to her in a couple days. I hope she's okay. Last I heard from her, she was all right. Maybe Cher is Cher live? Oh, okay, good. Oh yes, thank you, Melissa. You're right. Narc divers. Yes, I hadn't heard of them before, but people started checking them out. You know what? If you got a prison record, you probably shouldn't be involved in anything to do with YouTube because you're going to be outed. Your face, your record, your address, everything is going to be put online. If not by one person, then another. Well, we'll let her sleep. She needs her sleep. Oh my God. What makes you think you're number one, Chris? Seriously. Okay, still having a problem breathing here, but we'll get to it. You guys go off and do your thing. I need somebody to watch these two. I don't know. Annabelle's on vacation, so she is, I believe, in the air right now, so she probably can't come online. Okay, we have case 81. Okay, sharpen your wits here. Appalling, diabolic, and quite unacceptable. This is oh, Chris, please. Bradford, England, 1999, Watson v. Gray. The Bradford City soccer team had just brought over a promising new player, William Watson, from Southampton. I know. You're right, Misha. I'll put you in charge of that. You be the room manager, please. For £575,000. So it's 1999. Probably be a lot more now. In his third game against Huddersfield Town, a Huddersfield Town player named Kevin Gray slid cleats high into Watson after Watson had kicked the ball. The soccer tackle broke Watson's leg in two places. Watson sued Gray for a negligent soccer tackle. A witness at the trial described the tackle as very dangerous, appalling, diabolic, and quite unacceptable. According to court records, although a number of witnesses described the challenge as very late, in terms of time, it was only a split second late. Does Watson win? What standards should people use to decide what actions are part of the game and what actions are not? This is kind of like that. Where was that? Overseas with the hockey player that sliced that guy's throat with his skate and he died. He got charged with murder because people said that was a planned intentional. I was surprised. I would never heard of that. Oh my God. I think it's just I don't really think it's a romance. But who am I to say? They need to focus on those cases. Okay. So, or let's say football. I'm a big college football fan. Let's say a late hit. You do get penalized for that, but I don't think you get sued. Okay, so does Watson win? Watson sues. Watson sued Gray. Okay. I don't know that much about soccer. What do you say, Chris? Does anybody want to come up online or on panel with me? Just so I'm not alone since Eve's not here. Oh my goodness. Kicking balls, Chris. I say, let's see. If he's sliding. Oh no, Misha, I'm sorry. I'd say no, he doesn't win. I'm just gonna go out on a limb here. Oh, he wins. Whatever. This went to the Court of Appeals. Gray's tackle was negligent, and Watson did not assume the risk of such a violent soccer tackle. I guess I don't know that much about soccer. After watching video of the incident repeatedly, the judge said Gray's tackle was negligent and went beyond the risk that all soccer players assume. Gray failed to act like a reasonable soccer player who would have tackled with his cleats low when the ball was at Watson's feet. The object of the tackle should be to strip the ball from Watson, not break his leg. Okay, that makes sense. I don't know anything about soccer. Decisions about negligence in games can be difficult and vary from one game to another. However, the general principle is that players aren't free to do anything they want to an opponent. The roughness of their play has to fall within the scope of what a reasonable player finds acceptable. Oh my goodness. No, Melissa, I don't know anything about soccer, so I guess that, I don't know. I think all those games get kind of rough, don't they? But I can see the point. It's just strip the ball, not knock the guy down. So I guess if that's the point, which I didn't realize, I forgot to research the rules of soccer before we started. Yeah, you're just chicken, Chris. That's what I got to say. All right. Why did I put that up there? I thought I had. Like look at rugby. They beat each other with those paddles. I know that's a really rough game and everybody comes out bruised. Okay, here we go. 30-foot fireball rocks Russell Road. This is in Edinburgh, Scotland. 1963. Hughes v. Lord Advocate. Postal workers had opened a manhole to work on a telephone cable under the street. I can tell this isn't going to end well. They had set up a tent cover over the manhole to protect themselves from the weather. An hour after sunset, the workers left the site for a 15-minute tea break. Before leaving, they pulled up their ladder and lit 4 paraffin lamps around the open manhole as a warning. Why didn't they, close the manhole? Oh, thanks, Misha. Oh, I got somebody doing research for me now. I hit the big time. Tackles are not prohibited. That's awesome. I wish we would have known that beforehand. Okay, so while they were at tea, they're only gone for 15 minutes. How far could they go? Ages 8 and 10 walked by and decided to explore under the tent and beneath the street. Now, I would do that in a heartbeat because that's just the way I am. They put the ladder into the manhole and climbed down holding one of the lamps. Man, 8 and 10, they're just little kids. They're pretty handy if they put that. How did they put the ladder down the manhole, took the lamps, and climbed down when the workers are. Where did the workers go? Okay, I have questions. Upon returning to the surface, the 8-year-old Hughes accidentally knocked a lamp into the manhole. Uh-oh. The lamp broke and liquid paraffin leaked out, vaporized, and exploded. The explosion sent a fireball 30 feet into the air. Hughes fell back into the 9-foot deep manhole and was severely burned. What about the other kid? Experts reviewing the evidence considered the explosion to be a highly unlikely event. Hughes sued the post office in the person of the Lord Advocate for creating a hazard, then negligently leaving it unattended. Does Hughes win? Okay, let's get back to the subject. Chris, I'm going to take your wrench away. Okay, were the boys trespassers? I think this is what they call an attractive nuisance. Is it? It's not like a swimming pool, though. But, I mean, they should have put some kind of warning or danger or something, don't you think? Oh, you think Hughes wins, Misha? Melissa does too. Chris, yes. So you're saying that the post office has the duty to the public boy. Okay, I'm going to say Squirrely Girl doesn't know. Chris doesn't know. Because those two aren't paying attention. That's why they don't know. Okay. He wins. Yay. Hey, Rakes, welcome. All right. So, Rakes, Melissa, and Misha were correct. I was wrong. House of Lords, Scotland. Hughes wins. The post office had a duty to secure or watch the site. Burns from the lamps were foreseeable. The post office argued that the boys were trespassers, that they were negligent, and that the series of events that led to the injuries was not foreseeable. I think that's true. The judges, however, took a different view. They said that there was no trespass because the hazard was in a public space. The post office did not own the road or the space under it. Second, the court said the unintended work site was an allurement to children, just as a swimming pool might be. I think I said that. It's called an attractive nuisance court. There was a duty to secure or watch it, and the efforts to do this were inadequate. Both sides acknowledged that an 8-year-old was too young to be blamed for the negligence in this case. Finally, the court ruled that it was foreseeable that the boys would play with the lamps and that a lamp might break and burn someone. Therefore, burns were foreseeable. The exact sequence of events resulting in burns may have been improbable and surprising, but the end result was not. It just makes so much sense when I read these, doesn't it? Yeah, how did Chris get? You did not, Chris. I'm going to scroll up. Oh, you did say yes. All right. What was the part? Okay. Bad credit report leads to losses. London, England. This is also 1963. Hedley Byrne v. Heller and Partners. The three things I learned in law school were disclaim, disclaim, disclaim. An ad agency, Hedley Byrne, wanted to know if its client had good credit. So it asked its banker to talk with the client's bank, Heller and Partners. The bank said the client was a respectably constituted company considered good for its ordinary business engagements. The bank added a disclaimer to their credit report, writing that it was prepared without responsibility on the part of the bank or its officials. I think that's pretty intelligent of them. That's called foresight. The ad agency relied on the report. We've heard of someone doing that before, and bought ads for the client. Unfortunately, the credit report was negligently researched. The client was in financial trouble and soon went into liquidation. The ad agency was stuck with the advertising bills. The ad agency sued the bank for preparing a negligent credit report. The question before the court was not whether the credit report was negligently prepared, but whether the bank owed a duty to the ad agency. The ad agency said the bank did because it knew the ad agency would rely on the advice. Does Hedley win? That's the ad agency suing the bank. All right. Lucky guess. Yeah. Consider if I casually give free negligent advice at a party and another person relies on that advice and loses money, should I be liable? No. Are you liable for negligent statements at a job? What about negligently performing a service for free? Did they pay for this report? It asked its banker to talk with the client's bank. Oh, it said they did. Add a disclaimer to their credit report. Okay. Misha. So, no. Everybody says no. Does Helly? This is kind of similar to the case with the woman that asked her friend to find the car for her. It's almost exactly like that one. Does Helly the ad agency win? I'm going to say no. It loses. Yay, we're all right. There was no duty because the bank added the disclaimer without responsibility. The court said that the ad agency would have won if there was no disclaimer. In general, in cases where money is lost because of negligent advice, the advisor must be acting as a professional and possess a special skill, know if the person who will rely on their advice be able to foresee the costs of negligent advice. All those criteria were met, so without the disclaimer, the ad agency would have won. Consider these three situations of different people giving negligent financial advice. A journalist who gives negligent financial advice in a column. No. Probably not liable because they do not know who will rely on the advice. Well, this is kind of interesting. A plumber who gives negligent financial advice at a party, probably not liable because they are not acting as a professional financial advisor. A financial advisor who gives negligent financial advice to a client in their office is liable. Okay, moving on. Yes, you guys are nuts. Okay. Man struggles to get answers from city bureaucracy. This is Long Beach, California, 1986. De Vera v. Long Beach Transportation. Federico De Vera was hurt when a pickup truck hit the public bus he was riding. A witness said the bus driver spoke with the pickup truck driver and appeared to exchange insurance and driver's license information. But when De Vera followed up with Long Beach Transportation, it did not provide any information about the pickup truck driver that would help De Vera to recover money for his injuries. De Vera continued to ask Long Beach for the information, but got nowhere. So he hired a lawyer. Finally, Long Beach said that it had no record of the accident. Now the pickup driver hit the bus. Okay, De Vera sued Long Beach for negligent record keeping, which stopped him from recovering from the pickup truck driver. Long Beach said it had a duty to keep passengers safe by driving carefully and lawfully. However, it denied that it had a duty to keep accident information so hurt passengers could recover from an unrelated third party. Does De Vera win? No. No. I'd say no. I don't know. All right, you guys, cut it out. Seriously. Thank you, Rakes. Someone's being sensible. If Long Beach Transportation wins, what would injured passengers need to do at the next bus accident? Yeah, they'd all sue, wouldn't they? Yeah, I don't think that they don't know a duty to help you recover money from a third party. I believe that's right. I say no. Oh, Melissa says yes. Okay. He wins. Oh my God, you guys. Court of Appeals of California. I'll be darned. Well, Melissa, you are absolutely correct. Those rakes. Long Beach breached its duty to keep and preserve accident information for passengers. Who knew? The jury ruled that Long Beach was negligent. The Court of Appeals of California confirmed it. Long Beach had a duty to De Vera because De Vera was a customer. Moreover, it was foreseeable that failing to keep records would harm De Vera. The court said that requiring Long Beach to collect and keep the other driver's information would not be a burden. Long Beach would presumably need to give the information to its insurance company. I thought that same thing. They had to have had the information to give to their insurance company. Finally, the court said that the public policy implication of ruling for Long Beach would be a disaster. After every accident, each injured passenger would have to get the license and insurance information from the driver of the other vehicle. Excuse me. A busload of injured passengers lining up to get that information would be time-consuming and perhaps dangerous. Well, that makes sense. How come you guys all got that right and I got it wrong? Oh, Chris got it wrong too. All right. Yeah, Chris, you told me you were such a legal eagle here. Okay. Case 85. Do not pet the muskie. I'll put you in timeout. Here, that's no problem. I can do that. Do not pet the muskie. I had a bullhead as a pet when I was a kid. Fun fact. My mom complained that she bought a better grade of ground beef for the bullhead than she did for us. Every time I go by the lake where she set it free, I think of him. Okay. This is Minocqua, Wisconsin, 1993. Olhoff v. Peck. Squirrels. I do love squirrels. When the muskie's in the boat, you've got him. Till then, he's got you. That's an old Wisconsin proverb. That sounds right for any fish, doesn't it? Just a minute, I gotta mute myself a minute. Okay, I'm back. Oh yeah, Chris, you would know because you're a fisherman. Okay. I don't know. I'm sorry about my froggy voice. Jim Peck ran a nature farm that included a petting zoo and muskie pond. We used to go to the trout pond and feed the fish when we were kids. David Olhoff came to visit, and after having presumably enjoyed petting the fawns and goats, walked down to the musky pond. Elusive freshwater fish. There you go, Chris. You're right about that. Elusive freshwater fish known for their voracious appetites. Muskies often weigh 25 pounds and measure 40 inches. 40 inches. That's a pretty big fish. They have many rows of razor-sharp teeth and are legendary game fish in Minnesota and Wisconsin. Well, there you go, Chris. You must know all about them. Are they good eating? There was a muskie close to the dock, so Olhoff decided to reach out and pet the fish by its tail so it would not bite me. I would do that. Really? Oh, you don't eat them? What do you do with them then? Just stuff them? Big surprise, the muskie bit Olhoff. There was no sign by the pond saying, "Do not pet the muskie." Unlike many other states, Wisconsin had a list of the type of wild animals included in the strict liability law. Muskies were not on the list, so Peck was not strictly liable for Olhoff's injury. Olhoff sued Peck for his injuries. Does Olhoff win? Well, maybe Misha could Google that for you. I know it's a big fish. Could both parties be negligent? Are you saying, how old is this kid? David Olhoff, it doesn't say how old he was. Is he an adult? He's petting the fawns and goats. It pets the... Oh! Okay. Here's the catchphrase. He went to pet the fish by its tail so it would not bite me. So he knew that it could bite him. So he took that risk, I would say. That's what I would say. Sounds like a lot of teeth. Okay, so they're not strictly liable. Does Olhoff win? They can take a kid's hand off. You know, it doesn't even say if it was a kid. I wish we knew but he did know that it would bite. So, could both parties be negligent? Squirrely Girl says yes. Chris says no. I'm going to say, who the hell pets a fish? That's what I'm going to say. I'm going to say they're both negligent. Okay, Melissa says no. Melissa and Chris say no. Squirrely Girl and Rake say yes. I say 50% negligent. Ha! Appeals Court of Wisconsin, split decision. Olhoff is 90% at fault, which is the guy who got bit, but gets nothing because of Wisconsin law. Olhoff assumed the risk of being bitten when he decided to pet the muskie. Really? Oh, that's so cool. Yeah, don't post it or people will say it's Summer's face photoshopped on a picture kissing a fish. If you haven't been around here this week with Rose's picture, you know what I'm talking about. Okay, the jury did acknowledge. The jury believed that Olhoff knew there was a risk of being bitten when he decided to pet the muskie by the tail instead of on the head. The jury did acknowledge. Squirrely Girl knows what I'm talking about. You don't know how that pissed me off. I'm like, seriously? You didn't ask permission to use that picture in the first place. Wow. Yeah, go and read a couple of my posts, Chris, with One of those pictures of Rose you sent me when she was young. The jury did acknowledge that Peck had some responsibility for failing to warn guests about the danger of petting a muskie, but in Wisconsin, if the plaintiff was more negligent than the defendant, then the plaintiff could not receive any money. So even though Peck was 10% negligent, he did not have to pay anything. If Olhoff had been from California and hadn't any idea what a muskie was, thinking of it as an oversized goldfish, perhaps the percentages would have been reversed. After the accident, Peck added a sign that said, "Don't pet the muskie," because now it was foreseeable that somebody would try and pet one. I'll bet it is. I'll bet it is a cute picture. Yeah, you'll have to read my post. It was kind of ridiculous. Yeah, an oversized goldfish with teeth, yeah. And California people probably would think it was an oversized Oh, I'm sorry, I don't mean to insult anyone from California. I'll have to edit that out. Okay, case 86. Chronic fatigue syndrome sufferer. Why are these always like tongue twisters? Chronic fatigue syndrome sufferer sues for lost wages. This is Bury St. Edmunds, England. 1995, Page v. Smith. Ronald Page had suffered from chronic fatigue syndrome off and on for 20 years. He was recovering from a relapse that had forced him to leave teaching. According to coworkers, he was keen to start teaching again in the fall. Page was driving his Volvo when another car, driven by Simon Smith, swerved into his lane. The two cars collided. The accident was of moderate severity, and Smith admitted fault. Page was not physically injured, did not report feeling fear, and was able to drive his battered, soon-to-be junked car home. However, Page had another relapse of chronic fatigue syndrome and could not return to teaching. In fact, Page claimed, and his doctor agreed, that the illness had become chronic and permanent. Page sued Smith for his loss of work. Doctors testified at the trial that relapses triggered by stress were common among people who suffer from this syndrome. Based on the doctor's testimony, the judges concluded that Page was not faking his injuries to get out of work. Smith argued that he was not liable because psychiatric injury was not foreseeable in a minor accident that caused no physical harm or fear. Page argued that the type of injury did not matter because injury was foreseeable. Does Page win? Consider if there is an explosion, should anyone within the zone of danger, whether injured or uninjured, be able to recover for psychiatric injury? Must there be trauma beyond the ordinary anxiety, grief, or fear? Well, it wasn't a very severe accident. And I don't think it was intentional. Yeah, Misha. You don't think so? I say no. Squirrely Girl says no. Chris is going to wait and then type in the answer after I read it quickly. Rick says no. Boy, I'm going to say no. We're all wrong. Paige wins. Yeah, Squirrely Girl. Yeah, Eve would say, oh, these don't make sense. That's not right. I can hear now. God, I miss her. Okay, the psychiatric injury is foreseeable in accidents of moderate severity. Boy, I really don't agree with this. The court wanted to remove the difference between psychiatric and physical harm. Harm is harm. Psychiatric injuries no longer had to be accompanied by broken bones for the person to recover. The court wanted one test: was injury foreseeable? It did not matter how the injury presented itself. The court thought that any driver should reasonably foresee that they could cause psychiatric harm if they drive carelessly. I've never thought of this when I drive. The court referred to the principle that you take the victim as you find them. I've said that before, I know that, but it wasn't intentional. So do you really consider them your victim? If the victim has an eggshell skull, or in this case, an eggshell personality, you're still liable. The decision expanded the number of people who would sue because eggshell personalities are common, while eggshell skulls are not. Okay, I'm going to keep reading and then I'll talk. The court also limited recovery to recognized psychiatric illnesses occurring because of the accident, not for the trauma of the accident itself. The court's decision has been criticized, and I'm going to criticize in a moment, for removing the assumption of normal mental fortitude. Most courts require that the accident be either painful or terrifying enough that psychiatric injury would be foreseeable. I think this is a crock. Yeah, and you're causing me some stress right here. Okay, I think, yeah. I totally agree with you. Take your victim as you find them. But this was not a victim of a deliberate act. So I think this is really wrong. For one thing, he would have to prove that the stress was the proximate cause of his relapse. Not just that it could, but that it did. I don't think he proved his case here. I'm sorry. Oh my goodness. Oh my goodness. I'm going to put you both in timeout. You can discuss it there. Okay. Woman falls down unlit twisting staircase. St. Landry Parish, Louisiana. Who said they do weird things in real? Oh. I know some people in the UK. They're a little off. Okay. This is 1885, so this is an old one. Reynolds v. Texas and Pacific Railway Company. At the start of their long journey to Florida, Mr. and Mrs. Reynolds, their 3 children, and 2 servants, how lovely, were waiting for the train in the station's brightly lit waiting area. Wait, Louisiana to Florida? That's not that long of a journey, is it? When the train finally arrived at 2 a.m., passengers were told to hurry up to get to the platform. Yeah, that's right, Chris. I'll block you. The way to the platform was hazardous. The family had to grope their way down a twisting, unlit staircase that did not have a handrail. Mrs. Reynolds, who was overweight, fell and injured herself on the unlit stairs. The Reynolds family sued for her injuries. The company conceded that it was negligent for not having a light in the stairwell and a handrail, but said that their absence was not necessarily the cause of the injury. The railroad said that Mrs. Reynolds was also negligent because she might have fallen even in daylight, or that her fall may have been caused by her clumsiness, her weight, or any number of other possibilities. Does the Reynolds family win? Well, is the railroad responsible for providing evidence that something else caused her accident? Or is it enough for the railroad to show that something else may have caused her accident? Yes, Misha, me too. It's kind of distracting. That's why I'm not looking. So what are we thinking? I say, I think it's weird that they had to go down A twisting unlit staircase that did not have a handrail. Okay, I'm going to say Reynolds family wins. Just answer the questions, Chris. Misha. Okay, Rake says no. Does the Reynolds family win? I say they do. I say that the railroad was responsible. Who else would be? Supreme Court of Louisiana, Reynolds wins. The railroad provided no evidence to suggest other causes. The court said that the chain of events made sense. The lack of lights or handrail increased the chance of accidents like the one that happened to Reynolds. The fact that the railroad had a brightly lit waiting room also made it harder for the family to see once they walked into the dark stairway. That's a good point. I guess I missed that. They did say brightly lit waiting room. Once the railroad suggested that Reynolds was also negligent, it needed to give evidence backing up its claim, but the railroad produced none. The railroad's suggestion that the accident happened because Reynolds was overweight was rejected because she was not unwell, nor did she need help getting up or down stairs. It's worth noting that despite her injuries and pain, she still made the long journey to Florida and back. The judge wrote, courts consider the natural and ordinary course of events and do not indulge in fanciful suppositions. If the railroad wanted to speculate that anything else, weight, clumsiness, ghosts, caused her fall, it needed evidence. It's really odd. Well, this was 1885, that they would have a dark, unlit, twisting staircase. But yeah, to say she fell because she was overweight, that's kind of rude. All right. Case 88. We got 3 more here. Brother too late to stop rampage. Detroit, Michigan, 1990. Bell and Hudson, PC versus Harrington. Gerald Harrington got a call from his sister-in-law who said that his brother Robert had taken a shotgun, a can of gasoline, and a pistol and was going to the law offices of Bell and Hudson to demand the return of his $2,500 retainer. Gerald calculated that it would take some time for his brother to get to the office in downtown Detroit, so he decided to do the 5-minute walk himself and warn the lawyers in person. He miscalculated. By the time Gerald reached the law firm, the shooting had begun. He found his brother crouching with a shotgun in a corner. Robert had already killed one person, wounded another, and started a fire. The brothers argued and struggled. More shots were fired. Finally, the police came and arrested Robert. Bell and Hudson sued Gerald for not calling the police or the law firm before coming over on foot. Does Bell and Hudson win? Why did his brother's wife call his brother instead of her calling the law offices? Why wouldn't she be responsible? Consider, is there a special relationship between Gerald and the employees of Bell and Hudson? No. Once Gerald decided to rescue, was he negligent to not first call the police and law firm? No. No. I don't think they win. Oh, good night, Misha. Thanks for stopping by. Okay, Rick says no. I don't think they win. That's interesting that they call it Undertaker Rescue. I guess he did kind of. Yeah, Melissa, I don't know either. Well, so they're saying his sister-in-law didn't undertake a rescue? So they're saying Gerald, if he just didn't do anything, he wouldn't have been responsible, but since he did, he would be? Yeah, I'll go with no, too. No. Chris, what do you got to say? Oh, my goodness. Oh, they lose. We were all right. Court of Appeals of Michigan. There was no duty to call and warn the law firm. The court rejected the idea that the sibling relationship created a duty on Gerald to protect the general public from his brother. The court also rejected the theory that Gerald was negligent when he attempted to warn Bell and Hudson. While calling ahead may have been a better strategy for preventing the tragedy, the court said liability will only be imposed when the voluntary rescuer's actions increase the original damage. The actions of Gerald did not increase the danger and may in fact have prevented further damage. Well, he did wrestle his brother with a gun. That's just horrible. That's a horrible situation. I think his wife should have called the law firm or the cops. I certainly don't think that duty should be put on his brother. Oh my goodness. Okay. Case 89, golfer causes car crash. This is something I don't know anything about either. Never having golfed. Springville, New York, 1990. Ronaldo v. McGovern. Arthur McGovern was playing golf with his friend. He teed off on the 11th hole and badly sliced the ball. They said the spin of the ball caused it to curve right, which sailed over a line of trees out of the golf course and onto the highway. Roberta Ronaldo was minding her own business, driving her car on an empty road. She blinked and her windshield shattered. She lost control of her car and crashed. Ronaldo sued for her injuries, arguing that McGovern failed to issue a warning and that his play was negligent. Ronaldo said that McGovern had a duty to make sure that his shot stayed within the bounds of the course. Does Ronaldo win? Hell no. Are you kidding me? How could he reasonably foresee that? I don't think a golfer has a duty to keep the ball on the course, does it? This one just seems ridiculous. Oh my God. Yeah, no, there's no way. No, he doesn't have a duty to her. Okay, he loses. Thank heavens. New York has some common sense here. The accident was not preventable because even pros hit bad shots, so no negligence. The court believed that even if McGovern had shouted for the golfer's warning, there would have been no way for Ronaldo to hear. Even if she had heard it, there would be no way for her to avoid the ball. Well, yeah, even if she heard him yell, she wouldn't know where the hell the ball was coming from, right? Could have been going the opposite direction for all she knew. If Ronaldo had been walking on the next fairway and McGovern had not yelled for, that would be negligent. In that case, calling out would give her the opportunity to avoid the ball. As for aiming negligently, the court thought that it was not reasonably preventable. Even professional golfers sometimes hit bad shots. Sometimes they hit really bad shots. However, if Ronaldo had found a witness who said that McGovern was aiming at the road on purpose, then there would be a case for negligence because golfers have a duty not to aim off course. Without that evidence, however, it was just Ronaldo's bad luck. Well, what if the golfer hit a ball into the pond and when he went to get it, he was bit by a muskie? Just means Silly. Okay, here's the last one. Then I might have to take a break. Off-duty firefighter injured helping disabled car. Uh-oh. Phoenix, Arizona, 2006. Espinoza v. Schulenberg and others. I'm gonna, put paraffin lance around my cell phone and then take a 15-minute tea break after this. So, you guys watch out. Don't play with the lanterns. A one-handed golfer. Yeah. Firefighter Elizabeth Espinoza was off duty and driving home with her daughter when she saw an accident on the highway. She went to help. As she was reaching into the car to turn on the flashers, it was struck by another car. Espinoza was hurt in the accident. She received workers' compensation. Why? She's off duty. And also sued Schulenberg, the first car, for being disabled. So an accident. And Barrett, the second car, for her injuries. Holy crap, she's really trying to cash in. The trial judge ruled, without a trial, that Espinoza could not sue because she was a firefighter and already covered by workers' compensation. Espinoza appealed the judge's ruling. Does Espinoza win her case and get a trial? Okay, so we're not ruling in whether she wins or not, but just if she can take it to trial. What's the difference between the risks a firefighter takes when they are off duty and when they are on duty? If she was on duty, I can't figure out how she got workers' compensation when she's not on the job. Yeah, this is, and she sued both? I don't know, I'm having a problem with this. I mean, you don't get workers' comp if you're not working. She didn't stop in the course of her duties. And is reaching in the car to turn on the flashers, is that part of her rescue? It was struck by another car. So she's suing even the person that was broken down on the highway. Well, I definitely say she doesn't win against them. Yeah, everybody's confused by this one too. Okay, does she win her case and get a trial? Okay, well, we're not saying whether she wins the case, but just can she go to trial? The judge said that because she was a firefighter and already covered by workers' comp, that she couldn't go to trial. Okay, I say she does get to go to trial because I don't think getting workman's comp would preclude you suing someone for injuries. If I got bit by a dog on my route, I would get workers' comp for that. And I could also sue the person with the dog. Okay, so I'm going to say she does be able to go to trial. Yes. Yay. Supreme Court of Arizona. Espinoza wins. She gets a trial. Rescue is foreseeable. An off-duty firefighter without gear and backup is like everyone else. The Arizona Supreme Court said that firefighters should be treated like everyone else when they are off duty without their protective gear and support teams. The court wanted off-duty professionals to help people in need, So it made sense to offer them a way to get money for their injuries from the person who created the danger. The fact that Espinosa had workers' compensation should not keep her from suing. That's because workers' compensation does not cover pain and suffering for which she could receive money in a lawsuit. If Espinosa had assisted and been injured while on duty, she would probably not win her lawsuit because her injuries would be from work. Firefighters are paid and receive insurance and other benefits for taking these sorts of risks. Oh, Squirrely Girl, you did? Congratulations. I mean, I'm sorry you got injured. I had to sue my company. It took a long time. They wouldn't pay me workers' comp because they said it was not a work-related injury, and they wouldn't pay me disability because they said it was a work-related injury. I'm like, you got to pay me one or the other. What are you arguing with yourself? It's either is or it isn't. But they wouldn't pay me anything, so it took forever. It was a nightmare. And in the end, I won. I got more money than I thought I would. The lawyer said it's going to take 9 months, and at the end, you'll just want it to be over. And I said, no, I won't. I'll never just want it to be over. I'm going to go till the end. And he was right. At the end of 9 months, I just wanted it to be over. I'm like, oh my God, it went forever. Oh, Squirrely Girl, I'm sorry. Oh, that's horrible. Did you say that it was work? Oh, it was a work-related injury? That's terrible. Okay, so now I wanted to talk about this little boy that got shot. But first, do you want to say something about the Susan Morphew autopsy? Oh, that's good to hear. What do you think about that? I have never, this whole time, been convinced that Barry was guilty. And I know a lot of people have sworn he was guilty this whole time. But of course, they always do, right? I just didn't see. He wasn't near where her body was found. I still haven't figured out that. Yeah. But yeah, his phone didn't ping. That wasn't on his path. Of course, that doesn't mean he didn't have someone else dispose of the body. But to have those three, yeah, Chris, but to find three combinations of veterinary tranquilizer in her, and then when they had the search of his house, they found dart guns, syringes, and veterinary tranquilizer. So I'm saying, yeah, he's guilty. I don't really even need to go to trial for this one. I'm pretty hard to convince, but I'm convinced Barry did it. I'm sorry. I don't know how. I don't know why, but he did it. I can't believe I'm saying that. The cap in the dryer is just all out. Why wouldn't he get rid of the evidence in the house? Of course, he claimed he was in that hotel room, didn't he? I didn't follow that case a whole lot. Not like some of these other cases where I go deep on them. I really didn't pay that much attention. I do know that Donna Serafina said that Suzanne would be found in water, and she was wrong again, like she usually is. I know. I know. It's so unlike me too. I never do that. I had to wait to hear the evidence, but actually, I think the autopsy is definitive there. Okay, so let's look at case I wanted to look at tonight is a negligence case, allegedly. And I'm not sure you've heard of this before, but this boy was named Ralph Yarl. Yeah. But he's a big game hunter, right? Why would he be hunting chipmunks? I mean, that's not a trophy animal, and it's not a meat animal. Okay, now I'm just starting to... I can't believe I'm arguing for someone's guilt. Okay. So this was happened April 13th, 2023, and this was in Kansas City, Missouri. He did not die. He did live. So, but okay, that's enough. Yeah, it was his lame excuse. The 16-year-old African-American teenager was shot twice after ringing the doorbell at the wrong house while dispatched to pick up his twin brothers. See the background. He's a 16-year-old black male enrolled at Staley High School. His parents emigrated to the United States from Liberia. Friends and family described him as academically gifted and musician, intending to major in chemical engineering at Texas A&M. He is described as a lanky kid, 5'8", which is pretty tall, and 140 pounds, but he is 16. On the evening of the shooting, he'd been sent to get his siblings at the 1100 block of Northeast 115th Terrace. Shut up, Miles. He mistakenly went to a home less than a block away on North 115th Street and rang the doorbell. Investigators allege that Lester shot Yarl twice through the house's front glass door. The Kansas City Police Department responded to reports of a shooting near the home just before 10 p.m. Lester stated to the police that he believed that Yarl was trying to break in and was scared to death of Yarl's size. Lester also claimed that Yarl put his hand on the door handle, though Yarl disputes this. I mean, if you're going to break into a house, you don't ring the doorbell. Well, maybe you do, but do you? Yarl sought help and was refused at 3 different homes. I remember this. It was horrible. Before someone finally complied, neighbors found him lying injured in the street and called police, who found him with 2 gunshot wounds to the head and arm. The suspect was identified as 84-year-old Andrew Lester, an ex-Virginia resident who lived in Kansas City at the time of the shooting. His grandson and said Lester held a negative view of minorities. My cat's driving me crazy here. So Andrew Lester, an 84-year-old white man, was charged on April 17th with armed criminal action and first-degree assault, the equivalent of attempted murder in Missouri. Isn't it interesting how every state has different counts and different elements of each crime? And isn't there just one state that has murder in the 3rd degree? I thought that was interesting. The Clay County District Attorney stated that there was a racial component to the shooting. If convicted, Lester faces 10 years to life in prison. He has not had his trial yet. So national media attention rose toward the first of 4 unrelated shootings across the U.S. that week, which were all characterized by young people receiving gunfire for making harmless mistake. Well, this is kind of like the stand your ground and the castle doctrine, which are actually two different things. So I'm not sure which one applies in Missouri, what their laws are, but there's the murder of Kaylin Gillis in New York after she entered the wrong driveway, the shooting of two cheerleaders in Texas after they entered the wrong car, and the shooting of Kinsley White and her parents after her basketball rolled into a neighbor's yard. You know, these things are so senseless. I mean, you know, we talked about the other case where the two were robbing the house and that guy had set up his little lair in the basement to shoot him. I've had elk jerky and I've had moose. One of my customers gave me moose burger and moose jerky. So Lester was taken into custody. No initial charges were filed. He was briefly held in custody and was listed as out of custody and general release on the same day. The Clay County, Missouri Prosecutor's Office stated that it had not received a criminal referral from the Kansas City Police Department about the shooting. Later that day, it was announced that Lester would be charged with first-degree assault and armed criminal action. So the district attorney said there was a racial component. Assistant prosecuting attorney clarified that there is not a racial element to the legal charges that were filed. Legal experts noted that this was likely because a hate crime charge would have carried a lower maximum sentence. That's kind of sad. So this is not murder charges because he survived. He was released on bail later that same day. I think there's certain things, involved here. One is the publicity. I don't think they're going to get away with not charging him. Part of that is because of the racial component, I think, and they'd be accused of not caring about, a black person if they didn't charge him. However, I don't think he should have shot him. I definitely think he was negligent. Okay, so the community and the family demonstrated in front of the suspected shooter's home, calling for official charges to be filed. A GoFundMe campaign was created by his aunt to cover his medical bills. Receiving more than $2 million in donations and $3.3 million in 3 total days. Yarl was discharged from the hospital on April 16th. President Joe Biden called Yarl and his mother to discuss his recovery. Yarl and family and friends later participated in the Going the Distance for Brain Injury event in Kansas City, Missouri. Ahead of the event, Yarl's aunt spoke to reporters and stated that though Yarl was excited to return to his normal routine, they had to remind him to slow down as he suffered from debilitating migraines, balance issues, mood changes, and emotional comprehension along with PTSD. I definitely see that. So now the trial is, when did I say the trial was? It's later this fall, October 7th. What is FJB? Oh, I don't know. Okay, let me go back to this other article. Okay, I was shot in the head. Yeah, here's pictures of him. Poor kid. He's lucky he lived. Oh, they said it's still okay. He fired through a locked glass door without any words exchanged because he thought the teen was trying to break in and was scared to death due to the boy's size. He's only 5'8" and 140 pounds. Um, that's not a huge person by any means. All he did was ring the doorbell. I mean, if it's a glass door, he could see who it was, and the kid could see who he was, right? So obviously he wasn't trying to break in. No, Melissa? Oh my goodness. No, I don't think it's huge at all. I remember this in New York, the 20-year-old girl that pulled into the wrong driveway and was shot. That one was terrible too. Those close to the family expressed their amazement that Ralph survived and is recovering well. Thursday night, doctors were scraping off bullet fragments from his brain. Saturday, he was released from the hospital. That's amazing. But you don't really ever recover from a brain injury. That's a long process. They have, flares of anger and things. It's kind of sad. Some people should not. I agree with you. And actually, here in Michigan, they just charged the first person under the new law that makes you responsible for having your guns locked up when there's children in the house. And this guy's 9-year-old son shot himself with the guy's gun, and they just charged him. So that was a new law that was passed here. Okay, here's the circumstances. That night, Ralph was asked to pick up his siblings and mistakenly went to the wrong house. When he arrived at the house, Ralph said he rang the doorbell and waited a while before a man eventually opened the door and immediately shot him in the head, causing him to fall. Well, so he really didn't even wait to see what he looked like or how tall he was or anything. If he immediately shot him. The probable cause statement says while the teenager was still on the ground, the man then fired again, shooting him in the arm. Lester told police he opened his interior door and saw a black male approximately 6 feet tall pulling on the exterior storm door handle. 6 feet tall. He stated he believed someone was attempting to break into his house and shot twice within a few seconds of opening the door. The boy told the police he did not pull on the door. I believe him. I absolutely believe him. Why would you just open the door? Yeah, definitely bad parenting. Okay. Police responded just before 10 that night after receiving reports of a shooting. They arrived to find Ralph wounded in the street. The boy had gone to neighbors looking for help after he was shot. I remember no one would help him. He had to go from door to door. And then they didn't arrest him right away. Yep, 5'8" and 140. So he doesn't look very intimidating either. I mean, he's 16. He's just a kid. Okay, so his family is suing. She's suing, they're suing the homeowner and the housing association. I'm not sure how that's going to work. Well, that's because you're responsible, and your girls hunt, and they're trained for around guns, as they should be. Okay, the 7-page lawsuit filed Monday in Clay County Circuit Court by Yarl's mother alleges that Andrew Lester, 85, carelessly and negligently discharged a loaded firearm at an unarmed minor. He pleaded not guilty. Yarl's family is also suing Lester's Homeowners Association, Highland Acres Homes Association, claiming the organization had a duty to exercise reasonable care regarding the use of a firearm in and on the properties making up the association. I don't think they're going for the deep pockets there. And I don't think they could possibly blame the Homeowners Association. Do you? What do you think, Chris? Lester's attorney said in an email Monday that he's aware of the lawsuit and is in the process of evaluating and discussing it with his client. The Highland Acres Home Association did not immediately respond to the Washington Post request for comment. Yeah, I don't think so. Exactly. You need to teach them to respect guns. Okay. Missouri has a stand your ground and castle doctrine laws that say homeowners may use deadly force for self-defense if he or she reasonably believes that deadly force is necessary. Experts have told the Post that homeowners must be able to prove that an active threat existed. There was no threat there. The door was locked. He could see the kid. In the criminal case pending against Lester, his attorney has argued that the homeowner was acting in self-defense and that there has not been a shred of evidence that suggests race was a factor. Well, we're going to have to wait and see till the trial. He faces the maximum sentence of life imprisonment for the first-degree assault charge and up to 15 years for armed criminal action. October 7th. All right. Homeowners Association, no. Absolutely. No way. Not self-defense. It drives you nuts because it's about guns, Chris. I just think, some people, I don't know. I've heard people say if I had a gun, I would have shot him, which is a good reason for those people to not have guns. But, there's other ways of solving conflict. People need to, I don't know, I guess it's not all common sense. I mean, you don't have to shoot someone because you're mad at them or because they pissed you off or they walked across your lawn seriously? I have to stop and think. There was people on my route that I could just walk into their home without knocking and, they'd have me sit down at the table and feed me or whatever. God forbid somebody would have shot me. Of course, it was people I knew, but I guess they could say I was trying to rob the place if they wanted to. Yeah, they're not. He apparently had a loaded gun ready. It's just a shame that innocent people like this, yeah, I don't know. I guess we'll have to wait till the trial, and I'm kind of curious to see what's going to happen there. That'll be an interesting trial to watch. So anyway, thanks everybody for being here. Some of you anyway. I'm just kidding. So I guess I'm going to end it. That's all I have. Unless anybody has any questions. So good night, Melissa, Squirrely Girl, Chris, Breaks, if you're still here. Hey, Bob. Good night. Were you here earlier, Bob, or did you just pop in now? Was there wrestling going on? Wrestling, as we say in my parts. Oh, Melissa, I love it. You're very welcome. Thank you for coming. Rakes, thank you. Yeah, you have a good week too. Hey, Bob. Bye, Bob. Okay, thanks, everybody. Good talk. Yeah, you were here earlier. That's good. Thanks, Bob. Okay. What day is this? Tuesday. Rakes, funny one. Okay, we'll see you Thursday to talk about a really interesting, puzzling case. It's a mystery. So we'll see you then. Have a good time. Don't get hurt. Don't pet the muskies.